The next case on the call of the docket this morning is agenda number 13, case number 126927, People ex rel. Anita Alvarez versus 59,914 United States currency et al. Mr. Greenberg, are you ready? Okay, thank you.
This is a case that I'm a bit surprised has actually gotten to this particular point. We have a situation where an individual...
Counsel, you didn't identify yourself.
Oh, I'm sorry.
Okay.
I'm Steve Greenberg, and I represent the claimant, Amin Salam. Good morning. As I was saying, this is a case that I didn't really think should have gotten this far. Amin Salam went to the circuit court and filed a motion to vacate a forfeiture action more than 2 years after a judgment, an ex parte judgment, had been entered in that forfeiture action. He was the owner of a business, and that was known to the state. One of his employees was pulled over in a van that business owned while he was working, and the state moved to forfeit money that had been found in that van because the money was found with a quantity of narcotics. That employee was...
Can you just physically describe the evidences? Were they mingled together in a bag?
Sure.
The narcotics and the money?
Sure. So there was a what appears to be, from the description, a gym bag, essentially, that was, it said in the police report, pulled closed on the passenger seat of the van. Mr. Tyler, who was ultimately the defendant, had heroin in his pocket that appeared to be for personal use, and then there was a quantity of cannabis and about, I think it's 87 grams of cocaine, along with bundles of money in plastic bags within this closed bag in the van. And the state moved to forfeit the money. Mr. Tyler was prosecuted. Now, interestingly, the only notice Mr. Tyler got of the forfeiture was that the state sent one letter to his supposed address, the address he had given on the police report, and the address that he did not return to when he was finally released from jail. They never sent any notice to Mr. Salam or Mr. Salam's business that they wanted to forfeit the contents of the bag. They did send a notice to Mr. Salam's business address that they wanted to forfeit the van, and the state makes a big deal about that in their response. But they sent that notice to Mr. Tyler and an address where Mr. Tyler wouldn't get it because it was Mr. Salam's address, Mr. Salam's business address. They did not put any information, and there's no evidence that that notice was ever received by anybody, and I don't think the state maintains that it was received by anybody. Mr. Salam, the case against Mr. Tyler eventually was dismissed. And at that point, Mr. Tyler filed a motion under the statute seeking the return of the monies that had been taken. That's the proper procedure. The courtroom assistant state's attorney said, let me look into it and see if a forfeiture action was filed. The courtroom state's attorney did not know 2 years plus after the forfeiture judgment that a forfeiture action had ever been filed. In Cook County, unlike in some of the collar counties, they do not give notice of a forfeiture action to a criminal defendant when they appear for criminal court, which would seem to be the easiest way to provide notice. Instead, they operate...
Counsel, is it a coincidence that the motion to vacate was filed after 2 years after the drugs were found?
No, it's not a coincidence at all. Mr. Tyler's case wasn't dismissed until more than 2 years after the judgment of forfeiture. When Mr. Tyler's case was dismissed, he filed the motion that the statute says you should file for return of property that had been inventoried. All anyone knew at that point, including the courtroom prosecutor, was that this property had been inventoried. They took a few months to look into it, and then they said, hey, the money's been forfeited. We contacted the forfeiture unit at the Cook County State's Attorney's Office, and they said, oh yeah, that money's been forfeited. Can you provide us with some documentation showing that, a case number, anything? There were a series of emails back and forth, and this is in the record. They can see that these discussions took place, and then they just, for lack of a better term, ghosted us. They didn't respond to anything, and at that point, the motion to vacate was filed on behalf of Mr. Salam. There was
During all this period of time, was anyone in this record suspicious why the bag of money didn't come back to them? Was your client sort of surprised, like, where's my bag of money?
Well, it was inventoried as part of the criminal case. So it was, as far as he knew, what they call ERPS, Evidence and Recovered Property Section, at the Chicago Police Department. No one thought anything, because if he had filed a motion, if anyone had come in to file a motion in the interim, then they would have said, well, this is evidence in the case. It was found with the drugs, and it's evidence in the case. But this is the problem.
That doesn't make any difference, that the money was associated with the drugs? I mean, in the bag?
It makes a complete difference, and if they had followed the proper procedures, maybe that would carry the day. And this is the same, these questions are sort of the same analysis and the same problem that the appellate court had. That, in fact, it doesn't matter whether or not the drugs were with the money or not. What matters here is, was there notice of the forfeiture action? Did the state comply with what the U.S. Supreme Court requires, what this court requires for due process in order to have a forfeiture?
Let's assume for a moment there was a lack of statutory notice. How does that apply to whether or not this judgment was void under Belleville Toyota and People v. Castleberry, or simply voidable, which would bring the 2 years into play?
Because all of the precedent says that if someone is not served, if they are not given notice of a proceeding, that the judgment that's obtained against them is void. You can't put the onus on Salam. You can't put the
cases that you refer to, do they refer to Belleville Toyota?
No, they don't refer to Belleville Toyota. No, but they do say, and the U.S. Supreme Court and all of the federal cases and all of this court's precedents say that if someone doesn't receive notice, then a judgment is void. You can't put it on a potential litigant, on a potential claimant, to go searching to see if there's a forfeiture action. And there's a few reasons why.
So 40 years from now, 50 years from now, 60 years from now, your client could have come in and said, hey, that was my bag of money. I want my money back.
Absolutely,
Okay.
because he never got notice. He never got notice. You can't create a system where you incentivize people to not provide notice to someone else, and then when they get a judgment against somebody, say, well, all this time has gone by, so even though you had no opportunity to come in and litigate this case, you're out of luck.
So you want this court to say that a lack of notice is the same as a lack of personal jurisdiction?
Well, that's what the case law is, Your Honor. Even though it's an in rem proceeding, it's akin to a jurisdictional issue. The money isn't going to appear. The money is not a living, breathing thing. So in any case, you have to give notice to someone who can come to court and litigate the proceeding. That's just basic due process that everyone, anyone, even, let's just say, for the sake of argument, that Mr. Salam is a criminal. Criminals are entitled to due process. When we want to take their property, they're entitled to due process. When we want to enter a restitution order, when we want to forfeit something, they're still entitled to due process. We can't just say that because someone was arrested, that someone else should presume that there is a completely separate lawsuit that's proceeding against your assets, against your money. Had they given him notice, he would have been free to do nothing or to do something. But that would have been his choice. That's not the state's choice to make for him. And I don't think that there's ever been a case which says that you don't have to give anyone notice that you are seeking to forfeit their property, and you can do so, and they're just out of luck.
Is there a question about whether notice was required here? When you say someone, you can forfeit someone's property, the statute, of course, talks about notice to a property owner or interest holder.
Correct.
So here, the facts appear to be that this gentleman owned the van in which there was a bag next to the driver that contained the money and the drugs. So is that really a question about whether or not he was the property owner of the drugs and the money, or that he was an interest holder in the drugs and the money when he obviously was not in the van next to the money and the drugs?
Sure. Your Honor, the law says that you're supposed to give it to an interest holder, and an interest holder is sort of a wider net of people. A possible interest holder, someone who you reasonably believe may have an interest. So this was a constructive possession case that they were bringing against Mr. Tyler. These items weren't on his person. In a constructive possession case, I think it's reasonable to conclude that the owner of the business constructively possesses what is contained in the business vehicle. Amazon...
Would you really argue that if Mr. Salam had been charged with the drugs and the money, and the state's theory was, well, he wasn't there. He had nothing to do with the stop. He wasn't there. We never saw him close to the money. We never saw him close to the drugs. But we're going to charge him anyway for constructive possession. That would be okay under your theory.
Sure. I see it happen.
As the owner of the van, he was guilty of...
I didn't say he was guilty. I said they could charge him. I didn't say he was guilty. So Mr. Tyler's defense would have very likely been, look, I got in the van, this bag was there. It's not my bag, right? Mr. Salam's defense, very well under that scenario, in all honesty, would have probably been, I didn't know the bag was there. Tyler would have brought it in. But that's not, has nothing to do with notice. That has to do with criminal guilt and whether they can prove a case.
My question, though, is aimed at who is, under the statute, who is required to get notice? How broad of a group is required to get notice?
Right.
Here again, Mr. Salam is not present. He's not near the money. He's not near the drugs. Nothing like that. What is required under the statute? How far? Is it, since we don't know how that bag got into the truck, all the other employees, how far is the net that is required under the statute to get notice? I
think that in this case, he's the business owner, and it's a work van. That's quite clear in the police report, and in fact, the police report indicates that they looked up and they determined this. The business owner certainly should have it. If you have an Amazon van and the Amazon driver gets pulled over, surely you wouldn't suggest that the Amazon driver was responsible for the package, or that he was the owner of the package that's sitting next to him that's maybe going to go to the next delivery spot and it turns out might have drugs in it. But if you were going to forfeit that van and its contents, then you would give Amazon notice. And maybe that's not the best analogy, but you have a business owner, you're going to give him notice. People get prosecuted all the time for items that are found in their vehicles when they're not in their vehicles. Guns. I can't tell you how many gun cases I have where the police look in a vehicle and maybe nobody's in the vehicle at the time.
In your Amazon analogy, I mean, if the driver had drugs on his person, as this individual had drug paraphernalia on his person, that would tie him a little bit more potentially to the drugs. Here's the thing. The cases say a court may consider the character of the proceedings and the practicalities and peculiarities of the case, correct?
Yes.
Okay, now here a motion to vacate a default judgment was filed. Trial court heard arguments on it, and that motion was denied.
Correct.
Standard of review?
The standard of review, I think, here is de novo because it was a legal question because it went to the issue of notice.
Even though the court is considering the practicalities and peculiarities of the case, deciding who is entitled to or must get notice. That's still de novo, even while the judge is looking at the facts of where the package was and who was driving and whether the driver had drugs on his person?
There was no evidentiary hearing. As far as the driver having drugs, the driver had a very small amount of heroin and paraphernalia to smoke that heroin on his person. This is cocaine and cannabis, and it's a much larger quantity. So the state has said that it's a constructive possession case. It's different. If this money had been found in the driver's pockets, it might be a different situation because it would be in proximity to that. This is under the Cannabis Control Act that they moved. So it's related to the cannabis that was found in the bag. But yes, I don't think that the question is whether or not Mr. Salam was entitled to notice. That's the very simple question. And the appellate court and the trial court said, well, because Tyler had the same lawyer that Salam now has, me. Salam should have known, even though I didn't know. The appellate court said that because the state prosecuted Tyler, they believed that the drugs and the money belonged to Tyler, and that's good enough. So what is, and I don't mean to ask you, but what's someone like Salam supposed to do? Because they have no notice there's a forfeiture action. Tyler doesn't know there's a forfeiture action. The prosecutor in Tyler's case doesn't know there's a forfeiture action. The lawyer defending Tyler doesn't know there's a forfeiture action. And the money, the way it's listed in the circuit court in their complaint, they take each bundle and they list it by separate dollar amounts. So how are you supposed to know how to even find out if there's a case? You reach out to the state's attorney who's handling, in the brief before this court, and mind you, the state didn't even file a brief in the appellate court on this case.
You know, what can you infer from this case, from the timing of the motion and for the circumstances? This bag was not found in the trunk. It was found next to Tyler, right?
According to the police report.
Yeah, it was found next to Tyler. So this bag of money, you can infer, was missing, and if your client was the owner of the bag entitled to notice, he didn't do anything about finding out what happened to my $200,000.
He knew what happened to it. That's the problem. He knew what happened to it. It was sitting at Earps. That's all the information that the state provided.
So he knew where it was.
It was inventoried. It was an inventory in the criminal case. And as soon as the criminal case was over, Tyler said, "Give me back the property."
So if he knew early on in the beginning that the money was in the criminal case, he chose not to file anything. I'm looking at due diligence.
There's
He chose
nothing
not to file anything about getting his property back until after the time.
But there was nothing he could reasonably file. He can't file a replevant action to get the money back. There's a law in place that says that if it's property in a criminal case, when the criminal case is over, this is the procedure you follow. There's no procedure to come get property back during a criminal case or in the middle of a criminal case. And let's be realistic. If he had tried to get it back, and certainly he could have come in and said, "I want the money back," the money was sitting in there. He couldn't have succeeded because the state would have said, it's evidence in the case. If you have a quantity of drugs, a fairly substantial quantity of drugs and money together like that, the state is going to argue that the money is evidence of, indicia that you're drug dealing.
Mr. Greenberg, the statute says a complaint for forfeiture shall be served upon the property owner or interest holder. You're saying Mr. Salam owned the truck. The money was found in the truck. He's entitled to notice.
Correct.
That's your argument.
That's my argument. Yes, absolutely, because it's a work vehicle. And while the state may have had a theory in the criminal case that it was Mr. Tyler's. That shouldn't end the inquiry.
Was this a forfeiture as to the truck and the money, or just the money?
So what the state did here is that they filed a forfeiture against the money, and they sent notice of that to Tyler, which got returned to them after one attempt. They went to forfeit the van administratively, separately. They sent notice of that to the address where the van was titled, but again, put Tyler's name on it. They did not put the business name on it. That's in the record.
But this proceeding is, the truck or the vehicle is not an issue.
The vehicle is not an issue. The vehicle was a separate proceeding, and frankly, the vehicle was, I think, a 2002 van, so
Thank you.
I don't know that it would be worth pursuing. Thank you.
Thank you, Mr. Greenberg. Ms. O'Connell?
May it please the court, I'm Assistant Attorney General Erin O'Connell.
Could you speak up into the microphone?
I apologize.
Move the microphone.
No,
Okay.
Can you hear me now? Assistant Attorney General Erin O'Connell on behalf of the people of the state of Illinois. The issue in this case, before we even get to the question of whether the notice was proper under the statute and under due process, is whether a asserted owner of the presumed proceeds of drug sales can simply wait indefinitely until the risk of prosecution has passed, and at that time come into court and have that claim heard. I heard my opponent agree with the proposition that he could wait 40 or 50 years to do so. That is his theory, because he claims this was a void judgment. That's not the way that the law treats judgments. The law accords a certain amount of finality to judgments, and the court shouldn't countenance that sort of delay. So Section 214.01 is the vehicle through which a wronged party can come forward with information and seek to get relief from an improperly entered judgment. That's the framework that's used in this case. And typically, there are two requirements to a 214.01 petition that would apply. There's a 2-year time limit. Clearly, my opponent concedes this was well beyond the 2-year time limit. There is a due diligence requirement. That also was not satisfied here. The only way that this party can seek review of his claim is by completely avoiding the normal restrictions on a 214.01 petition. And his argument is that he's entitled to do that because this is a void judgment. And that's simply not the way this court has explained voidness in this context. And Castleberry was an important case issued in 2015. The court explained very thoroughly that courts until then had loosely used terminology like void. But really what void should be understood to mean is a lack of jurisdiction. And so cases that have admittedly used words like voidness in explaining the lack of notice to an interest holder in a forfeiture proceeding, those cases were using that term loosely and without considering the limited nature of the voidness doctrine. Instead of rendering the judgment void, a claim like this of a lack of notice would instead render it voidable and be subject to the usual requirements. And this case presents a sort of unique opportunity because the court hasn't really explained what voidness means in an in rem context. But what the court has clearly expressed before this is that in rem cases involve jurisdiction over the rem, over the property. And they do not require personal jurisdiction in the way that most other cases require it. So they don't actually require that the state acquire personal jurisdiction over interest holders. And that is why the full service of process of a complaint doesn't apply in an in rem procedure. The statute sets forth the criteria for notice, but that's less onerous than would typically be the case to acquire personal jurisdiction. So there is no requirement that there be personal jurisdiction. There's certainly no dispute that there is a requirement for notice. There's a requirement in the statute. There's a requirement under due process. But again, this is a type of claim that has to be properly brought by someone who has failed to receive notice. And there's the reasonable limit that that person would have 2 years to come forward to try to challenge the judgment unless he can raise some exception to the 2-year limit, for example, fraudulent concealment. He would also have to show due diligence. And I disagree that it's unjust that this type of a claimant is subject to this requirement. We require it for any type of individual seeking relief from judgments. There has to be minimal due diligence in asserting one's rights. There are 2 separate periods here, and I just want to focus on one because it's really dispositive. And that's that there was no diligence in filing this petition after learning of the claim. So even he waited until the charges were dismissed against Tyler. He learned at that time that there had been a forfeiture judgment. We know that this is even as late as June or July of 2018. He waits 4 months. He waits until November 2018 to file his petition for relief from judgment. That alone precludes relief. That is not diligence in asserting one's rights. There is also, preceding that, a lack of diligence. Someone who had ownership of $200,000 would have every reason to be following up. That money has been seized. I'm going to keep track of where that money is and keep tabs on it. That should have motivated the diligent owner to find out about this forfeiture proceeding sooner. I mean, the circumstances here are telling in that there was this delay after the statute of limitations had passed. So it was only after Salam could no longer be prosecuted for possessing the drugs in this bag that he came forward and said, oh, that is my bag. That does have the drugs in it, and it has the money that was commingled with the drugs in very suspicious packets of $50,000 here and $50,000 there, and it's actually got residue of cannabis on it. That's also my money.
So, Connell, is that in the record, that comment
I'm sorry.
about he waited till after the statute of limitations?
So the state did point that out in the circuit court, and the appellate court did note it as well in a footnote in the opinion, that the statute that governs this had expired, I believe, in September 2018. And then, so he knew about it a couple of months before that. He didn't act. And he even didn't act immediately after the September date. He continued to wait until November. So it's a circumstance that can be inferred. Certainly, counsel would be aware of the statute of limitations that would apply. And so he did wait until there was a time when there was no risk of prosecution. And that should certainly factor into what is supposed to be an equitable remedy under 214.01. The petitioner, I guess he's a claimant or a movant. In this case, he filed a petition for relief from judgment. He has not established an entitlement to equitable relief under these circumstances where he clearly waited too long to assert his claim. And I did want to address briefly just the merits of the argument here on the notice, because there were some questions earlier. The standard for who receives notice is set forth in the statute, and it has to be who the state reasonably believes to be the owner or interest holder in the property. So there is a boundary here. The state has to act reasonably. The reasonableness standard carries with it a fact-specific inquiry based on the circumstances. Here, under all of the circumstances, the state reasonably determined that this was Tyler's bag with the drugs and the money. And the circumstances were that he was alone in the van. This was a bag that was on the seat next to him. It was an unlocked bag. Counsel conceded that if it had been in his pockets, it wouldn't have been something that Salam had an interest in. But it was kind of analogous to the pockets. It was essentially a personal bag, a satchel on the seat next to him. So it is comparable in that way. There could be other circumstances where it would be more reasonable for the state to infer ownership of the personal property by the van owner, and that would be if it was in a different place in the van, if it was in a locked container. Those would be circumstances that would tend to show this belonged to Salam and not to Tyler. But under these circumstances, the state reasonably determined it to be Tyler. Therefore, the state served notice on Tyler. And Salam, to the extent he wanted to assert an interest in the property, he did not have an entitlement to notice. He had standing to come to court and raise a claim. And he would even have the ability to claim relief from judgment under a lack of notice theory, but his time for doing that expired long before he acted.
Counsel, was there anything that prevented the state from giving notice to Mr. Salam?
No. So, and the state certainly, I think, could have reasonably determined otherwise. The state reasonably could have determined that Salam was entitled to notice. The claim of ownership in these circumstances is a double-edged sword. As I think questions have sort of hinted at, the state, in determining who owns the contraband, is making a conclusion about who is engaged in criminal activity. So while the state concluded that Tyler was the owner, it charged Tyler with crimes in relation to this property. The state could have had perhaps a more tenuous theory that Salam would also be in possession of or liable for property found in his van. It was tenuous enough here that they weren't required to reach that conclusion. And the court should really hesitate to adopt a rule that would impose this sort of liability on any vehicle owner for personal property that appears to be associated with the driver of the van when he's alone in the van, because that does carry additional consequences in terms of potential criminal liability for those individuals.
You're suggesting location is an important factor about decisions of who's an interested party and who should receive notice. I mean, if it was in the back of the van or in the trunk of a car, would that make a difference, you think?
Yes, I think that would factor into the analysis of the reasonableness of the determination and the circumstances. Another circumstance would be, say, a locked glove box compartment where the property was located. Here, the circumstances clearly indicated that this appeared to be personal property of the driver, as opposed to bearing some connection. It was also mentioned that the bag didn't appear to be associated with the business in any way. There was no markings of the business. So there was no obvious connection to the business itself and the business owner of the van and Mr. Salam. But under different circumstances, the court might reach a different conclusion.
This bag was located right next to Tyler.
Correct. So in this case, it was on the passenger seat. So he's the driver. It was an unlocked bag. It had been pulled closed. There were, I think, reasons to believe it would be similar to a purse, for example. It was more of like more of a personal property of the driver. So, but to the extent that it could have gone either way, the state's determination that this was Tyler's and Tyler's alone was not unreasonable. So for that reason, the state satisfied the notice requirement. But again, Mr. Salam can still come forward and raise his claim if he does so in a timely manner, and his failure to do so here should bar relief.
Opposing counsel argues de novo review applies to the trial court's decision.
So I would tend to agree that, so 214.01 petitions can be governed by two different standards of review. If it is based entirely on the pleadings and the arguments and it's a legal question, this court has said that a de novo standard of review is appropriate. If there is fact-finding involved in the decision, then the court typically applies an abuse of discretion standard. To the extent that Salam is relying on alleged factual errors by the court, that would seem to suggest an abuse of discretion standard, but it does seem to be more of a legal argument, a legal determination as to that this was not a void judgment, that there was proper subject matter and interim jurisdiction, and that as a legal matter he was not entitled to notice. But certainly if this court finds that abuse of discretion standard applies, then Salam is not entitled to relief under that more deferential standard. So we'd ask this court to affirm the judgment.
Thank you, Ms. O'Connell. Mr. Greenberg?
Thank you. Thank you. Just a couple of factual issues I want to address here. First of all, the appellate court made a big deal about the fact that there was nothing indicating that it was Salam's bag. There was no monogram or anything like that. There was also nothing indicating it was Tyler's bag. And this was a large work van, not a minivan. So it has the giant hump in between the driver and the passenger. Now, the state said something about, if it was a purse sitting on a seat next to, this is akin to being a purse. I drove down here, actually, and she'll...
Mr. Greenberg, can you put the microphone in front of you?
I'm sorry.
Thank you.
I drove down here, and she'll appreciate this because I think she's watching. I took my fiance's SUV. When I got in the SUV, there was something belonging to her on the passenger seat of the car. It was a piece of female's clothing, okay? I put it in the back as I left. But if I get pulled over, that's her clothing. That's not my clothing. It's her car that I'm driving. And her item is on the passenger seat. This idea that because someone is the driver of the car, that whatever's on the passenger seat cannot belong to the vehicle owner under a reasonableness standard is just simply absurd. When the appellate court said that there was no evidence this was Salam's bag because it wasn't monogrammed, it's not Tyler's bag because it wasn't monogrammed. When they say
Who owned the drugs in the bag?
Who owned the drugs in the bag?
Who possessed the drugs in the bag?
Who possessed them or who owned them are two different.
Yeah, owned.
So I think that they were jointly owned, frankly, by Tyler and Salam, who subsequently got indicted together by the feds.
Who's the other person?
Tyler and Salam, who got indicted by the feds for drug dealing. And at the time, the case was dismissed. And this leads to the second argument about diligence and waiting for the statute of limitations. They got prosecuted together. They got sentenced to federal time. When Tyler got sentenced to federal time, the case was dismissed. And this is clear from the record. And I think a fair reading of it is because he was now in the federal penitentiary.
Now,
So
you're telling us that the conviction of Salam and Tyler involved the same bag and money that
No.
involved in
They
this
were
case?
separate. They were separately. But I think that when you're asking whose it was, it doesn't matter whose it was. So I'm accepting for the moment that the drugs in the van, they can belong to both. That doesn't. Tyler was entitled to notice. Salam was entitled to notice. It has nothing to do with who's guilty of the criminal case. What I'm explaining is they were subsequently federally prosecuted for a different drugs. And when they were federally prosecuted, they dismissed the case against Tyler. That's when the case got dismissed. And realistically, it was probably because he was in federal custody doing federal time.
The case involving this money was dismissed.
The case involving these drugs was dismissed.
When he got convicted in the other case.
Right. So I don't think there's any reasonable belief that they would have prosecuted Salam. But more importantly, when that case was dismissed, the lawful procedures were followed to return the money, and the state's attorney's office was contacted in July of 2018 on behalf of Salam, to see what happened. Provide us with a case number. Provide us with evidence of a forfeiture. Provide us with anything. He wasn't hiding. He wasn't trying to evade a statute of limitations of any kind whatsoever. There's no reason to believe he would have been prosecuted by February of 2018 after they had dismissed the case against Tyler. But it was Tyler who first asked for the money back because that's what the law said. And it was the state in the courtroom who didn't even know that a forfeiture action had been filed. If the state had said during the course of the criminal case, there was a forfeiture action filed against these monies, it would have been before 2 years went by. It's the state's fault that so much time went by and no one knew anything.
May I ask you this in terms of, if we agree with you, and this judgment is vacated, what happens next? Can the state file a new petition, give new notice? Is the $223,000 directly returned to Mr. Salam? Or does Mr. Salam, in a new proceeding, have to demonstrate that he was the owner of the money and the drugs? What happens?
I think that because of the passage of time, and because it is a void judgment, that there can't be a remand for a new hearing. And I think that
How about a new petition? New petition for
no,
forfeiture?
because the time has gone by. The statute is very clear, and the precedent is very clear, that there are strict time limits on a forfeiture action, and in other cases, similar
Okay,
cases.
so I assume it's correct. They cannot file another petition. So what is the result? Is Mr. Salam going to get the $223,000 back if we agree with you?
Yes, Mr. Salam should, and that's on the state. They didn't do it right. So is distasteful as that may seem, because maybe he is a drug dealer, maybe he isn't a drug dealer, whatever the case is, the burden was on the state to do this properly. And if they don't do it properly, then yes, Mr. Salam should get his money back. Just like they could have charged him with the drugs. They didn't charge him with the drugs. Maybe he got away with it. That's just, we shouldn't be sitting here and trying to make value judgments that, well, in this particular case, it's really unfair. We don't really want this guy to get back because we don't like him or something like that. There are procedures in place. There are rules in place. We're all bound by the rules. It's like any other statute of limitations. It might seem unjust, it might seem uncomfortable, but yes, Mr. Salam should absolutely get the money back.
Could this bag and all its contents be considered contraband?
Under the law, I mean, the contraband is clear. The drugs are clearly contraband, and no one's expecting those to be returned, and no one asks that they be returned.
So is everything in the bag contraband? The bag, the contents, all contraband?
No, they have to prove, because money is not outwardly contraband, so under the case law, the government would have to establish that it was contraband in order
And
to.
If at an evidentiary hearing it was established it was contraband, what happens then? If everything in the bag is contraband?
At what point? At what point, Your Honor?
If it's considered contraband, what happens?
If it had been established, I mean, that's the essence of a forfeiture case. If it had been established that it was contraband in the forfeiture case, then it would have been forfeitable. That's what the law says, certainly. But they didn't do that, and they can't now go back years later. If they had, they just can't do it. I mean, all the case law, unless all the precedent, including federal precedent and U.S. Supreme Court case law, which requires notice in these situations, reasonably calculated to allow an interested party to know what's going on. Without that, and you blow the statute of limitations, then the money has to be returned. You can't go back and get a redo. There's no case that says that. Are there any other questions? Thank you.
Thank you, Mr. Greenberg. Case number 126927, People ex rel. Anita Alvarez versus 59,914 United States currency et al. Will be taken under advisement as case agenda number 13. Thank you, Mr. Greenberg, and thank you, Ms. O'Connell, for your arguments this morning.